Mr. Marcy. Can you hear me?
Yes.
Okay.
Good morning, ladies and gentlemen. Today is January 23, 2025. It's cold outside. This is the City of Oviedo's Special Magistrate hearing session for the month of January of 2025. We have several items on the agenda today. The first item is a parking citation, and the person cited is Toby Vega Dedurian. Are they here today? All right, I understand they may have already paid that fine, so we'll move on to the next item. The next item on the agenda is compliance report case. That's case CE 24-000042. And that is the case involving 469 Franklin Street in Oviedo, parcel ID 10-21-31-300-0560-0000. Who's appearing on that today?
I am, sir.
All right. Ms. Moyer, just state your name for the record.
Yes, sir. Yes, sir. Code Enforcement Supervisor Shakuria Moyer, City of
Right.
Oviedo.
Yes, what do you have for us today on this one?
Yes, sir. So this is a compliance hearing for Gray King, property address 469 Franklin Street, case number CE24-00042. I have 10 pages to submit in evidence. May I approach the bench?
Yes. All right. Is anyone appearing today on behalf of GRE II King LLC? Right? I will accept these 2 pages into evidence as the city's exhibit number 1. All right, what do you have?
Yes, sir. The first 4 pages are the property record card showing that the Gray or GREII King LLC is still the owner of the property at 469 Franklin Street.
All right,
And again, this is a compliance hearing. So on October 24th of 2024, you issued a finding of facts order requiring the respondent to come into compliance with a couple of things. I'm just going to go over briefly what those things were. If the respondent intended to use the property for a multifamily after November 18th of 2024, then the respondent is restricted to a maximum of 4 units and must comply with the DN classification. In any event, the respondent must comply with all then applicable zoning and building requirements, and at that time, the respondent had not. In any event, the respondent shall apply for all permits for all work that has been done without a permit. He shall ensure that all applicable plans are submitted, reviewed, and approved, and ensure that the units are no longer occupied. We were able to verify that on November 7th. However, the respondent did not come into compliance with submitting all the building permits and everything needed to transition the building to get it approved by the city.
so which provision of the order have they failed to comply
Yes,
with?
yes, sir. So in Section 2,
Okay,
he did not comply with anything other than having the units not occupied. Allowing us to do the inspection, he complied with, but everything else, the submittal of the applications, any building permits, getting that approved, he did not take care of that.
so let's go through paragraph. The first paragraph, they have or have not complied with.
Yes, sir. So with the first paragraph, the single-family residential, he did not intend to use it for a single-family residential and instead intended to use it for a multifamily. So he was supposed to submit that paperwork by November 18th, or after November 18th. That was when the new code went into effect. He did not do that.
Okay, so again, paragraph by paragraph. So he hasn't applied for rezoning,
No, sir.
okay? And he hasn't complied with all applicable zoning regulations,
Yes, sir, that is correct. He has not.
okay? And the fourth paragraph, he shall apply for permits for all work that's been done. He's not done that?
No, sir. It was supposed to be submitted, reviewed, and approved. There was no approvals on any of those, any permits, anything that he may have submitted. Nothing has been approved.
But he has applied.
Yes, sir, I believe for mechanical and an electrical.
So he's applied for the permit, but it's not been approved,
Yes, sir.
okay?
We have had nothing's
And-
done. And then also, he was supposed to pay a $500 fine. And we have not received that. I'm sorry, that's in section 3.
Yeah, that's section 4,
Four.
actually, isn't it?
Yes, sir. Corrections, number 4.
Okay. And he has allowed inspection, however?
Yes, sir.
Well, I guess technically you could be applying for a Massey hearing on the fine,
Yes, sir, that's
You
what we're here for
intend-
today. Yes, sir, the master hearing.
okay? Has the respondent been notified of the hearing today?
Yes, sir.
They understand that we could be setting a fine today?
Yes, sir. Once I go through the package, I did not receive, or I received the letter back, return mail back, so he did not accept the mail. However, it was posted to the property to ensure service.
So service was by posting,
Yes, sir.
and the respondent refused the mail service.
Yes, sir.
Well, I see that the date for compliance was December the 30th.
Yes, sir.
That means as of today, this would be what, 24 days of, or 22 days of non-compliance.
Yes, sir.
That comes up to a $3,300 fine for non-compliance through today's date.
Yes, sir.
Will be issuing an order to that effect, but also there's the $500 fine that remains unpaid.
Yes, sir.
So the total fine will be $3,800.
Yes, sir.
I will enter an order to that effect. I will also enter a new order continuing the accrual of $150 a day fine until compliance. So the $150 a day fine continues to run until they come into compliance.
Yes, sir.
Okay, that will be my order.
Yes, sir.
Thank you.
Okay.
next item on the agenda is case CE 24-000727. The respondents are Rodney Wilson, Glenda Wilson, and Robert Agostina. The property involved is 298 Geneva Drive, Oviedo, Florida, 32765. Parcel ID 10-21-31-0000-00A0. And the allegation is that there's a violation of Land Development Code 3.4A. Involves a special event permit. Who is here today to speak to that case? Anyone who's here to speak to that, please come forward. All right. Okay. All right. All right, first, let's get everybody's name. Shakira Moyer, I know. Step to the microphone and please give me your name.
Robert Agostini, or Bob, and we own Brisket's Barbecue.
Okay? And this gentleman?
Blake Wagner,
Okay, and what is your role, Mr. Wagner?
civil engineer.
Glenda Wilson, property owner.
Okay?
Rodney Wilson, property owner.
Okay.
Deborah Pierre, Deputy Development Services Director.
Teresa Korea, Development Services Director.
Karan Bartley, Zoning Administrator.
Okay, you, start over.
Karan, C-A-R-R-O-N, Bartley, B-A-R-T-L-E-Y, Zoning Administrator.
And it's what administrator?
Zoning.
Okay. Okay, sir.
Harris Burns Cadle, Development Review Manager.
What was the first name again?
Harris, Harris. Last name is Burns Cadle, B-E-R-N-S.
Spell that again slowly.
My last name?
Yes.
B-E-R-N-S hyphen C-A-D-L-E.
Okay. Who else is here to speak? Is that everyone? All right, would you all step forward and raise your right hand? Do you solemnly affirm that any testimony you give here today will be the truth, the whole truth, and nothing but the truth? All right. We'll start, I guess, Ms. Moyer, with you.
Yes, sir. This case being brought before you is for 298 Geneva Drive in Oviedo, 32765. Case number CE 24-000727. I have a total of 40 pages to submit in the evidence. May I approach the bench?
Yes. Has the respondent seen these?
Yes, sir.
Okay. All right, I'm going to admit this 40-page composite exhibit as the city's exhibit number 1. All right, go ahead, Ms. Moyer.
Yes, sir. Pages 1 through 4 are a copy of the property record card showing that Glenda and Rodney Wilson are still the property owners of 298 Geneva Drive.
Okay?
Yes, sir. Pages 5 and 6 The city issued Mr. Robert Agostini a special event permit on September 12th of 2024 that will go through December 12th, approximately 90 days, to use a food truck trailer for his business at the property 298 Geneva Drive. Page 6 is highlighted and shows that the special event permit was going to expire on December 12th of 2024. Number 3, under section planning, advised that no further extensions will be granted.
Okay?
Page 7 is a map showing the property at 298, and then there's another location of 302 North Central. One is the owner for Mr. Glenda and Rodney Wilson, 298. 302 will come into reference. They are not in violation. They are not in violation. However, it is a property being used by the business owner, Mr. Robert Agostini.
Okay, let me sort this through.
Okay.
The North Central Avenue, where is the trailer located now?
Yes, sir. It's at 298 Geneva Drive. And that's the smaller triangle on that map.
And who owns that parcel?
Yes, sir. Glenda and Rodney Wilson.
All right, and on the 302 North Central Avenue, who owns that?
Yes, sir. Mr. Agostini?
It's my business partner, Brad Lambert.
So it's owned by Mr. Agostini. Okay, and
Yes, sir.
you're saying that the 302 North Central Avenue is not now in violation?
No, sir. But we're going to refer to that property in a little bit to go over some improvements and some development that was supposed to take place on that property.
Okay?
Okay. So on December 3rd, which was approximately 9 days before the expiration of the special event permit, staff met with Mr. Robert Agostini to discuss the special event permit and advised him that the code enforcement process will begin if the trailer was not removed by the expiration date on the permit. On December 16th, a reinspection was conducted and the trailer that was authorized on the special event permit remained on the property after the expiration date, thus being in violation. So pages 8.
So again, I want to make sure I'm following the train.
Yes, sir.
So Mr. Agostini, on December 3, was notified that the special event permit that he'd been granted
Yes, sir.
had expired,
Was going to expire.
was going to expire.
Yes, sir. So they met with him on the 3rd and advised him that the permit was going to expire on December 12th,
Okay?
that if the trailer was still there, he would be in violation.
Okay?
Okay. Pages 8, 9, and 10 are photos showing the trailer on the property at 298 Geneva Drive.
The trailer is now on Geneva Drive.
Yes, sir.
Okay?
Yes, sir. So a notice of violation was sent on December 17, 2024, with a corrective action date of December 19th.
Was a special event permit ever issued for the Geneva Drive address?
Yes, yes, sir. It's on, it's pages 5 and 6 is the special event permit for this location.
For Geneva Drive?
Yes, sir.
Okay. So we're talking about 2 permits that have been granted, or one has been extended.
No, sir. So right now, we're just dealing with 298, and
Okay.
he received a special event permit back on September 12th, with the expiration date of that permit of December 12th. This was for the 298 address.
Okay, let me back up again.
Okay.
So on the 298, there was a special event,
Permit issued.
and when was that issued?
Yes, sir. September 12th of 2024.
All right, and when did that expire?
Yes, sir. December 12th of 2024.
And who applied for that permit? Was that Mr. Augustini?
Yes, sir.
Right.
Okay.
Okay, when was a permit issued for the Central Avenue?
Yes, sir. Those special event permits, they're in the back. I'm going to get into the 302.
Okay.
I'm going to tie in the relevance for you a little bit
Okay.
later because I don't want to confuse you. So I'm just going to start with what he's currently in violation of, which is just at the 298 on
Okay.
Geneva Drive, but I'm going to tie in the correlation between
Okay.
302, okay?
All right,
Okay. So page 11 is a copy of the notice of violation. I'll wait till you get to it.
okay,
Okay? In that corrective action, he was advised that he needed to remove the trailer that was authorized by the special event permit no later than December 19th of 2024. And it was a reminder sent that no further extensions will be granted per the special event permit.
okay,
Pages 12 and 13 is a certified copy of a mail receipt. I have the white card, the certified mail receipt is page 12. Page 13 is the signed green card for the property owners. We served notice to the business owner as well, so that will be page 14. This went to the 298 Geneva Drive address for Mr. Agostini, and then page 15 is a signed certified mail receipt.
all right, Brisket's Barbecue. is
Yes,
that-
sir.
That's Mr. Agostini?
Yes, sir.
Okay, go
There was
ahead.
also an affidavit of a hand delivery for this violation as well. So he was notified in person with a notice of violation, and because there was a discrepancy with the mail, we wanted to ensure, I just included that so we would have service.
Okay,
Okay, so he was advised to have that removed by the 19th. On the 20th, there are some photos showing the trailer still remain on the property. That's going to be pages 17 is just showing the address of the location. Page 18 shows the trailer still on the back of the property.
I'm familiar generally, I drive by that almost every day. That is what, a barbecue type trailer?
Yes, sir.
Okay. All right, go ahead.
Yes, sir. So page 19 is a copy of the notice of hearing that was prepared on the 20th of December 2024, advising of today's hearing.
All right,
Page 20 is a copy of the certified mail receipt. This was sent to the property owners. We did not get a signed green card back. Page 21 is a copy of a certified mail receipt for the notice being mailed to the business owner at the 298 address. Page 22 is a copy of a signed green card from the business owner at the 298 address. And to ensure service, there was, I did a hand delivery. So page 23 is a copy of an affidavit of hand delivery.
okay,
Okay, so before we proceed to page 24, Mr. Marcy, I'm going to go over and discuss in detail and provide more details and a timeline from staff conversations and meetings with Mr. Agostini, which dates back to over a year ago. On January 16th of 2024, we received a complaint regarding work being done without a permit. Staff met with Mr. Agostini, and in an attempt to help Mr. Agostini, suggested that he applied for a special event permit. Now I want to clarify the information for the addresses. 298 Geneva Drive is the primary address for the business and the violation. That's what we just discussed. 302 North Central Avenue will be mentioned, and it's a secondary location and was used for an extension of the business for Mr. Agostini. This address was supposed to be the long-term solution for Mr. Agostini, as it was more suitable and comparable for what his business needed. He has a growing business, so that's why we're mentioning 302. 302 is not in violation. However, 302 was supposed to be the long-term solution. So the trailer was supposed to move to the 302 location. That site was supposed to be developed for future business use for Mr. Agostini.
Okay.
Pages 24 and 25 is a pre-application meeting that was had on January 31st, 2024. This was with Mr. Robert Agostini. At this pre-application meeting, staff met with him and discussed that he would need to submit some applications, a site development order to be exact, in order to be able to temporarily use the trailer at this location. Staff encouraged Mr. Agostini to apply for the site development order, as this would help his growing business. Mr. Agostini applied for a special event permit. So he came in, discussed that he had a property he wanted to use, he wanted to turn it into a place for his business, okay? And that he also was going to apply for a special event permit. Special event permit would allow him to be able to operate his business as far as a short-term solution. And this pre-application meeting, which involves several of the staff members from different departments, it's highlighted. It includes planning managers. It involved fire department. It included our engineer, building official, and our director. Those meetings include typically everybody, so that anybody coming in to discuss something or a project or maybe some land development, they can receive comments from everybody and get correct information to be able to move forward with whatever process they're going to do for whatever site they're trying to develop. And so I got it highlighted on page 25 that
Ms. Moyer, move the microphone a little further down. It's cutting in and out.
okay,
Okay?
is that better?
That's better. Thank you.
Okay. So with on page 25, it was noted at this pre-application meeting that this business owner came in, so this would have been in year 2023, regarding a code enforcement complaint. This was involving trailer use. So we were coming into contact with Mr. Robert Agostini back in 2023 involving some code enforcement stuff. And at this particular meeting, a site development board and an architectural design was advised that is what we required to Mr. Robert Agostini to change the use of the residential property to a commercial commissary kitchen. So we're talking about the 302 address. So we were discussing with him what the process would be if he wanted to use that property as a part of his business. He was advised that a special event permit was required to resolve the code enforcement case, and that the trailer at the house would be inspected by the fire department. So he was advised what he could do at that pre-app and what for the intended purposes that he was suggesting that he wanted to use it for. So the city, on February 19th of 2024, last year, issued a special event permit to Mr. Robert Agostini with an expiration date of May 19th. So this gave 90 days for him to have the trailer to be able to used, again, all while trying to come up with a plan for how we intended to extend this business and come up with a more permanent solution, because the special events are temporary. On April 3rd, another pre-application meeting was held. City staff, Mr. Agostini. Mr. Agostini brought in Mr. Blake Wagner, who's a civil engineer, Horn, to discuss in details the site development order as well as the comprehensive application that was needed to replace conservation future land use, downtown transition. So they were discussing what would be needed to develop. That meeting is highlighted by, I highlighted all the staff that was in attendance to that meeting as well. So the city met with him again to discuss that. Pages 31 and 32 is another special event permit issued to Mr. Robert Agostini. It was issued on June 3rd, 2024 to September 1st, 2024. Again, giving Mr. Robert Agostini 90 days to begin the site development order application process. Mr. Agostini was advised that no further extensions will be allowed for this location. This is going to be at the 302 North Central location. On page 32, under planning number 2, staff advised Mr. Agostini an permit that a site development order application shall be submitted prior to the expiration date of the special event permit, which was on September 1st. Or the food truck trailer shall be removed. And all operations shall cease. This was on September 1st. No further extensions have been granted at that location. This is a 302. On June 12th, there was another application meeting. June 12th, 2024. Mr. Robert came in with Blake Wagner, Horn, civil engineer, and they discussed things involving the site. Development services wrote several things, but the thing I want to highlight is the reason for the special event permit. The reason the special event permit was not going to be extended is because it was temporary use. Is a maximum of 6 months. The special event permit was what was preventing the code enforcement case from moving forward. Effective and efficient applicants must be made to prevent code enforcement proceedings. So we needed for him to begin to put in things in place to for a long-term solution so that he could resolve his code enforcement issues. Pages 35 and 36 notes another pre-application meeting held on October 2nd of 2024. On October 2nd, this meeting was with Mr. Agostini for the business primary location, which was 290 Geneva Drive. And they advised Mr. Agostini that a site development order, final engineering application, will be the only way to have the trailer permanently on that site. Staff went over this process in detail. On page 36, I've highlighted that the things that are important in this meeting, again, is showing that we needed to apply for or submit an application for the site development board of final engineering, that the applicant is notified to the development services know when the trailer was removed. Otherwise, the code enforcement case will be revisited with a notice of violation. Pages 37 through 40, timeline, because I know I started with what was currently going on, and then I went back to what was happening all before. so that you can understand that this has not just, this case didn't just start in September. This has been going on since January. So it's a timeline for you to refer to, and I the page number. It goes a little bit more detail. These are going to be formal meetings, so it's going to be pre-application meetings. Anytime Mr. Agostini came to the city, if it was informal, there's some things that was discussed in email, some things that was discussed with the civil engineer, Mr. Robert. Again, just showing that the city was meeting with Mr. Robert, expressing the concern, answering any questions, and hopes that he will get a long-term solution for his situation. So, again, this information was discussed about a timeline, notes information given to Mr. Agostini. It shows the city has given Mr. Agostini all opportunities and information he needed to get a site approved to be able to operate his business, everything he deemed essential. To date, we have not received a sufficient application to begin any process, and the food trailer remains on the site in violation as the permit expired on December 12th of 2024. This concludes my presentation at this time. Deputy Director of Development Services, Deborah Pierre, will come up to discuss more information.
All right, a couple of questions, Ms. Moyer.
Yes, sir.
So, as of today, Mr. Agostini has not applied for site plan approval?
Yes, sir. We have not received anything sufficient to be able to move forward. An application, all the documents required, fees for the application, that will be discussed as well by the planning department.
Right? And once he applies for approval, I'm assuming it'll go through the normal process
Yes, sir.
and then be approved when it meets
Yes.
all the requirements.
Yes, sir. We'll be able to have a site and operate it. Yes, sir.
All right, and all of this has been explained to Mr. Agostini.
Yes, sir. Several pre-application meetings. Yes, sir.
But today, the one that's in violation is the one on Geneva Drive.
Yes, sir.
Okay? Who else has anything to present?
Good morning, Your Honor. Can you hear me okay?
Yes.
Okay, perfect. So the city, as Supervisor Moyer talked about, the city has been dealing with Mr. Agostini since January of last year. So in order to get a food truck approved in the city, you can only do it in one of two ways. First, it would be a special event application, which Supervisor Moyer mentioned is temporary. Our special event applications are only good for 14 days. That's what the code says, the duration. But the land use administrator can extend a special event permit, as we have been doing with Mr. Agostini. The second way is with the site development order application, to make it a more permanent structure. And we're going to go into the site development order application, what he submitted, because he did submit a site development order application, but it was not sufficient at all. So we'll go into that. So the special event permits are temporary, and the duration is 14 days, and it's supposed to be for one non-reoccurring event on the site. So in Mr. Agostini's case, we extended it twice on, and I'm going to talk about both properties as well. So it started with the 302 Central, and the reason why it started at 302 Central is because the neighbor next door complained that he was operating a business on that property, and it's a residential structure. So we went out, we went out to go see what was going on, and indeed he was operating his restaurant business on that site. It was the grill, the smoking. He was also using the house for his office operations for the restaurant. So he came into the city because we went out and told him he was going to come in and do a special event, the site development application. He decided to go for the special event application. And so that special event application, I know you have it in your packet, so I'm just going to give you This one, is it okay if I approach? the-
Sure.
These are both special events.
Right. Well, since I already have these, I will simply place them in the packet with the other
You do.
documents.
So if you look at the one that was issued on February 19, the expiration date was May 19. If you look at under fire department's comment, and I highlighted the area that you need to look at under the fire department, it says a house and barn cannot be used in conjunction with this event. And it was just because we knew he was using the house and barn for his commercial operations, which in order to use that property for commercial, you have to convert it with a site development order application. He didn't go through that process. And then it says that the house and barn are not approved for non-residential uses. And if you turn over under planning, on the second page, it says the special event permit only covers the use of the food truck trailer. The applicant shall cease the use of the house and barn in connection with the food truck trailer and restaurant. So that's a part of that first special event. So May came, May 19th, because that's the expiration of this permit. The applicant wanted to extend the permit. So he asked for an extension, we extended it. So the second permit that you have in your packet, which is permit 240157, if you look at the highlighted, this is also 302, the same property. So the date that it was issued was June 3rd, and it expired September 1st. If you turn over on the back, under planning, I highlighted it for you. Number 2, under planning, it says a site development order application shall be submitted prior to the expiration date of the special event permit on September 1st, 2024, where the food truck trailer shall be removed and all operations shall cease by Sunday, September 1st. And then it says no further extensions will be granted. So we have already talked to him. This is showing you that we already talked to him about doing a site development order application on 302 Central. So we had that conversation, and you'll see it in the pre-application minutes, the notes that you have in your packet, that we've discussed what a site development order application is, what is a sufficient application, what needs to be provided with the site development order application. So he's already aware of that, of those requirements. The next permit is going to be the one on 298 Geneva Drive. And that's permit number 24-0233. And if you turn to the second page of that, under planning number 2, it says it's the same information. So now this one is for Geneva Drive. This is the 298 Geneva Drive. So he moved because he did not submit a site development order application for the 302 Central. He moved the trailer to 298 Geneva Drive. And this is where the actual restaurant is located. So in this special event permit application, we tell him as well that he has to submit a site development order application prior to the expiration of this special event permit, which expires on December 12th, or the food truck trailer shall be removed. And in this one, we did not grant an additional extension like we did for 302, because by this time, this is almost a year. We didn't want to grant any other extension because he had not submitted a site development order application from the first two special event permits on 302 up until now, which was at this point, December 12th. He hadn't submitted anything. So we had a meeting with the supervisor. Moyer talked about this meeting. We had a meeting, and it was with the city managers, with the development services director. It was with Harris Burns. He's going to come up and talk about the site development order. It was with myself. And at that meeting, we talked about, the city manager talked about how, because he hadn't submitted a site development application to the city, that we were going to move forward with the code enforcement on this property, which is 298, because the permit we knew was going to expire, and at that time, he had not secured an engineer to provide plans for the city. So at that meeting, the city manager did discuss that if he submitted a site development or application, that the city would be willing to talk to you, special magistrate, to give him an extension. But if he did not submit anything, and when we talked about an application, a site development order application, all those pre-application meetings we had with him, we talked about what a sufficient application is. So the city manager said, if you submit a sufficient application, the city would be willing to go to the special magistrate and request more time so that we can review the site development order application. Now, I'm going to have Mr. Harris Burns Cato, who's the development review manager, come up and talk about what he submitted. Mr. Agostini submitted a site development order application. No application fee, no plans. It's an insufficient application, so we can't even start our review. And after a certain amount of days, we have to basically either give it back to him or just, we can't do anything with it. So we haven't started the review yet. So I'm going to have Mr. Eric Burns Cato, the development manager, come up, and then I'm going to come up behind him as well to finish my points.
All right, Mr. Harris?
Your Honor, with
Raise that microphone just a little
no
there,
problem.
okay?
You hear well now?
Sure.
Perfect. In relation to the application that was submitted on December 19th of 2004, an application for development engineering was the city of Oviedo. It was reviewed for sufficiency. What was submitted with the application was an incomplete application form, along with an agent authorization form. By the way, just to correct the record, on 2 North Central Avenue, Brad and Lambert, owner of that property appraiser, and the agent authorization form was from Brad and Lambert, giving authorization to the applicant here record, along with environmental assessment. Those are the only items submitted to the outstanding sufficient application. These items would be submitted to this. A boundary survey with legal description, engineer plans, architectural plans to do an architectural development order is not necessary for sufficiency, but it could be provided. Landscape and irrigation are required, site plans or project plans, drip generation and distribution, water capacity letter, solid waste capacity letter, along with description and justification for deviations, and application fee and its. And so those items are outstanding. The applicant was notified December 19th. The application is in. Please fill out the application completely, submit plans, and verify all required documents. Submittal checklist is required to be submitted to this application, and then in follow-up emails we provide this elongated list and enumerating the different items deficient on.
Okay?
And my last point today is that when you hear from the applicant, you may hear that if the trailer is removed, that we may shut down his business. And I just want to make clear that the city is not trying to shut down his business at all. As a matter of fact, we're not doing anything related to his actual building. He has not submitted a sufficient application. We cannot stand before you today requesting additional time for the applicant because we don't have anything to review. So our request today is that the trailer be removed.
So the city wants the trailer removed.
That he's not in compliance with the special event permit, and he has not submitted a special site development order application.
If he were to apply again for a special permit for the 298 location, would it be granted?
We we cannot grant because it's only once per calendar year.
Okay.
A special event application can be granted, and it's for one non-recurring event, no more than 14 days.
Okay. I want to make sure I understand. The property is owned by the Wilsons.
So the property at 298 is owned by the Wilsons.
Wilsons.
Now, the property where the site development order application should be filed at is at 302 Central.
Okay. But where the trailer is now, the property is owned by the Wilsons,
Yes,
but the business is owned by Mr. Agostini.
yes, that is correct.
All right. All right, but Mr. Agostini is wanting to develop a permanent location on the Central Avenue. Okay.
Yes.
All right. Thank you. All right, Ms. Correa.
Mr. Marson, good morning. What I would like to is clarify the challenge for us on extension of the special event permit is that once a sufficient application is submitted, it will take approximately 4 months to 6 months to approve the site plan. And then it also has to be able to have the compliance with the code. He also has to do the site construction. So we're really talking about almost a year of extension. So right now, what we have is that if in January this process would have started, then he would have now a compliant site. But if we're starting now, if we still don't have a sufficient application, the extension for temporary permit will have to be at least a year to be able to have a trailer on site. So
If
this
he
is the
were to
challenge
apply
for us.
tomorrow with a sufficient application, it would take 4 months to a year?
So there is a question if it's going to impact an area that is under conservation, future land use regulations. So if that is the case, we're talking about comprehensive plan, the future land use map amendment, which is another application. Since we do not have the plans yet, we do not know how many applications he will have. If he doesn't impact that area, it will be a quicker application, right? But if he does, then we'll have to do an amendment to a future land use map. So that is another application, and that's why we're saying 6 months. It could be 4 to 6 months, depends on the review of an application of a site plan or any application. Our time is on the clock. So when applicants submit plans for us, we have, the first review has a maximum of 28 days, a second review is 21, the third review and any subsequent reviews is 14 days. But we do not control the time the applicant has to make the plans compliant. But this is the challenge for us. We want to have, we need to have his business. There is no judgment or value on his business. Business is a good business for the city, and we recognize that. But we cannot have a trailer that is not compliant with the code being there for so long.
Okay, thank you.
Thank you.
Anyone else have anything on behalf of the city? All right, who wants to speak on behalf of the respondents? Mr. Agostini. Just state your name into the microphone. I know who you are, but
Sure. Robert Agostini, owned Brisket Barbecue, 298 James Oviedo.
okay. What do you have for us?
It's all this going on. I want to thank the city. Like I said, we've met several times, and I'm not a person of great wealth or anything. I started a barbecue business. Started with a food trailer where we served the public, and did that for a few years. Ms. Glenda's, Ms. Wilson's building became available, and we thought, hey, let's see if we can get in there, and we won't have to drive our food trailer home every night. Sounded like a good idea. I did not realize how busy we get. In the first year, we won best restaurant award. I don't even know how we did that. And then someone told me, congratulations on your Critics' Choice Best Barbecue of the Year from the Orlando Senate. I didn't even know we had that. I found out by someone telling me. So, and we have some other awards. And this just grew, thank God. Right now, we employ about 23 employees. My payroll is just $1,000 or two shy of $40,000 a month. And these people are college students, to adults, to career and chef people that work there now. And the city and I have the same goal, is to be compliant. I really appreciate everybody on the city. People say to me, and you know, it's a small town, people here, we got to move the trailer. First, the trailer is never used to serve the public. The building that we're in is 300 square feet. We do anything. It gets pretty crowded. I often say it's like working in a submarine. And there are several components. There's, when you walk in the door, there's the people that cut the meat, cash register, and then right behind that person, in a little 4x3 table, they do all the preparation of the food. That doesn't leave any space, not even a foot, for the masters that we have to cart meats, get them prepared, put them on the smokers, take them off the smokers, put it in refrigerators or warmers afterwards. So we just need space for that. The food trailer suffices. We don't cook anything in the food trailer. We don't serve the public. All we do is process the meats that we smoke, and we have 2 refrigerators in there, and 1 warmer. That's all, and supplies. That's it. It's state approved. We meet all state code regulations. So, not sure what to do with that. But after a lot of counsel from them, so at first we had it there and they said, we can't have it. Okay. So we didn't know what to do. We found a place around the corner, 302 North Central, and we rented that place. It's commercial for a restaurant. So we thought, hey, perfect. So we rented it for a few months and purchased it. And we thought, okay, this is our plan then. We're experiencing growth. The property now can't handle growth. So we'll build a restaurant around perfect. So we mentioned the city, so we're going to bring the food truck there. They issued a permit. And like I said, a permit is only good for 14 days. The people that administrate for the city have gone bent over backward to help us. They gave us an extension, 3 months, another 3 months, and some of the people say, well, what's the big deal? It's just a trailer in the back. But the big deal is they have to abide by the code. That's what they get paid to do. Whether they like the code, don't like the code, doesn't matter. That's their job. And I respect that, and I appreciate your kindness with us too today. So my goal is to get the trailer off property. As soon as we can get 302 in compliance, that'll go the same day. Because we won't need, we just need somewhere to put it, process everything. So, Kimberly Horn, the engineer, Lake Work represents, was recommended to us. They did the Ace property that's next to the Ace building. So we contacted them. He went to some of the meetings with the city. And another thing too, it costs a lot of money, which is kind of new. And you're not talking like it's $500, $1,000. It could be $50,000, $60,000, $100,000 into plans and surveys and all that stuff by the time we're done. So, okay, so we hired them, and they went out and they submitted, started the submission. He can explain what was submitted. I don't know all that stuff. But we did submit things to the city, application, et cetera. The one application that was submitted in December requires a lot of components, such as an architectural plan. Well, that takes kind of months to get together, and money, et cetera. So, and then holidays, and, you know, just we submitted what we could. So Blake submitted that. And then, again, he can tell you what he else he submitted. So we're trying to meet their timeline, although we're not doing the best job, not because we don't want to, just because of all the complications of putting it all together in the timeline they want, but we are working hard at it. So,
I have a few questions. You own the property at 302 Central.
I have a business partner, Brad Lambert. He's my brother-in-law. He lives in Indiana. He's a commercial developer. And I'm the working guy. He's the capital.
Does he own the property or do you own it?
He bought it in his name, yes. 302 North.
So he owns the property.
Yes.
So, you-
Yep.
so what is your plan? To lease the property from him? What exactly are your plans for 302?
We are 50/50 business partners in the Brisket's Barbecue LLC. So our plan is to build a restaurant on that property. And we've started the process for that by hiring Kimberly. And we're just going through the steps.
And this is your brother-in-law?
My brother-in-law, yes, sir.
So, again, I want to make sure I understand. You want to put a, brick and mortar or
Yeah.
building on that property?
Right. No trailer or anything.
How far have you gotten with your plans for the brick and mortar building?
Well, a lot of steps. First, we purchased the property. Second, we hired an engineer. They've done an environmental study on it already. They've done some site development. Would you want to, should I ask him to come up right now?
Sure, if he wants to speak, and this is Mr.,
Yes, sir. Morning.
and this is Mr.
Blake Wagner.
Wagner, okay.
Kinley Horn Associates. Yeah, so I fully understand the application we submitted in December was incomplete, insufficient. We currently weren't under contract to submit the site development order. We just submitted the application itself, although it's incomplete, and we were intended to pay the fee, but didn't receive any fee details because the application was insufficient. We are currently under contract to provide services for the site development order. That was earlier this week. We received full, go ahead to start on the plans. The environmental assessment for the site has been complete. That was submitted with the site development order application. The client, Mr. Bob and Mr. Lambert, have secured services of a geotechnical engineer for the geotechnical analysis. That's required for the design engineering plans. And then we'll be starting, once we get the geotechnical analysis, we'll be starting the full construction plan for the site. The plan is to construct roughly a 3,400 square foot standalone restaurant. And then once we get that geotechnical analysis, we can submit to the city within 6 to 8 weeks.
Have architectural plans been drawn up for the building?
I'm just a civil engineer, so I don't believe they have, but I'm not responsible for that. Mr. Lambert, Mr. can speak to that.
But as of right now, no sufficient site development application has been provided to the city.
Correct.
Why is that?
These things take time. Back in December, we weren't under contract to provide those engineering services. The plans take 6 to 8 weeks to complete. And then we just got to go ahead this week to perform those services.
How long will it take you to put in the hands of the city a sufficient site development?
6 to
Applica-
6 to 8 weeks.
So you're really 6 to 8 weeks away from even initiating the process.
Correct.
Mr. Agostini, how long have you known that a site development plan would be necessary?
We've talked about it since we started talking with the city,
How long, well, on what date?
probably over a year at this point.
When did you first hire the engineer?
I think February 2020. We have been moving forward. Again, I'm not an engineer, I'm not a commercial builder, so I just have to refer to information and request to get me, and then talk with Brad and find somebody to fill the requirements that they have, and that's what we've been working with.
Well, right now, of course, the trailer sits at the back of the small building. When you had the trailer over on 302, was there a building there at that time?
Yes. Right now, 302 is next to the 34, next to the Ace Hardware. So there's a house on the front, and there's an old barn in the back. And when they initially said we couldn't have the trailer on the restaurant, that's when we found the property, and we said, we move it over there, because again, it's all commercial. We didn't realize the business use was still residential, never converted to commercial. The property was commercial, we thought it was, but they were kind enough to issue a temporary use, and put our smokers and the trailer, and then I have a truck that was used for Meals on Wheels as a hot box. And we would transport meats to the restaurant. And the state approved that, using the truck to do that. So that worked out okay for a while. It's just round up. And then that expired. And during this time, I'm having meetings with them. And I would initiate meetings. It wasn't like they called me, you got to do something. No, I would initiate it because I want to be proactive and do the right things. And again, they've been very kind. So here we are today. The restaurant's grown. Oh, also during this time, I have looked and for places to move the trailer to, well, or not even have the trailer. Maybe there's a second generation restaurant that closed down. And we actually did find one place, by the post office plaza. The realtor, they're going to knock that down tentatively. It seems like they will within a couple of years. It would have worked out. Let's say the last 2 years would have worked out because we wouldn't need the trailer at that point. We do all our meat carving in that location. But it didn't work out with the requirements for us. So it didn't work out. I also looked at warehouses all around the city, outside of the city, and there are warehouses, not many, but one would allow a smoker, another one would, but it's so expensive. And don't forget, everything that we do outside of this is another layer of money. And what we don't mind doing as long as it's there, but, just compound.
And the trailer is the smoker.
What we have is, we have the little building in front, and then we have our smokers. And then the trailer right next to the smoker. And they just cut the meats in there, they put them on the smoker, take them off when they're done. That's all we use that for. It's really an extension of the kitchen. There's no public comes in the trailer, we don't serve anything. No stoves, nothing like that.
All right, anything else on behalf of the respondents? Anyone else want to speak to this? All right, thank you, Mr.
Thank you, sir.
Agostini. I would like to hear from the city again on exactly what they see as the solution. Who wants to speak to that? Planning, the zoning manager, Ms. Correa? What do you see as the solution to this short of just shutting down the trailer?
It's, again, it's the challenge for us, right? Technically, let me tell you, Mr. Marcia, we don't even have technically an application. There was no fee paid to the city, right? So we are calling it insufficient application.
Yeah.
But if you don't pay a fee,
Well, you don't even have an application for 298.
we do not. So, again, we would like to help, but I don't see a time frame that we can work on the city not opening a precedent, because a special event permit is supposed to be temporary. The code gives two pathways for the trailer to be compliant with the code, either on a temporary basis through a special event permit or through a site plan. And it could be a site plan in either locations, right? It could be a site plan in Geneva too. Geneva, the site has some challenges. It's a small site, has, still a right-of-way on the back that could be vacated, but it's not processed. So I cannot see how we could offer another year, because this is really, again, if they apply tomorrow, right, we just heard that they will need at least 6 to 8 years even to be able to apply. While we're speaking, the trade is still not compliant.
Yes, well, the only real violation in front of me today is the 298, and it doesn't seem to have been even an effort to apply for site plan, site development plan for that property.
Not for no.
Okay.
Although we have talked about it, there are some geometry challenges with that small property. So I'm really, what we would like to see is the trailer moved for another property, or if it's within the city, then it's going to be a special event permit, but again, a maximum of 3 months. It's hard for us to say that we are committed to allow a year, right? Work with you, whatever you propose, but it's hard for us to propose a year extension on a temporary structure on site, because we haven't done that before.
All right, thank you.
Especially since we're already within a year of having the initial conversation. So it will be 2 years that the trailer will be in existence without that permanent structure.
And let's see, the temporary permit that was granted was for how many days?
It was for 90 days.
90 days. Okay.
And we grant special event permits for 14 days. That's what the code allows. And then it allows the land use administrator to extend.
Okay, thank you. Mr. Agostini?
Yes, sir. Thank you. On the 298 site development, we had discussed that. And she mentioned that there are some geometric blockages or whatever to actually doing a site development order. The building was built in 1965, and how it's configured is there's the property itself from the building, the property line doesn't go out very far. It goes towards the back, Franklin Street. To the left is residential. To the right is a right-of-way potential street at some point, which he said might be needed. And then to the right, residential. So this was a carve-out made residential. So we talked about the site development order there. And if you use today's code, it could not get approved because you would have to have setbacks for various components. There's no room for setbacks. You would have to have storm water drain off, and there is no place for storm water drain off. The code is built and it should be fair to all restaurants, which it is. When you compare the building from 1965 to today's code, I think it just presents some basic challenges from that time to this time. So that's why we chose not to submit the site development for 298, because as we would talk about it, and they would say, "Yeah, submit it, but we have challenges to the site. I don't think it could get approved." So that's the only reason we never submitted on there. But just trying to figure it out and
Okay.
working at it.
Okay, thank you. Well, the problem is, this situation cannot continue indefinitely. It seems to me, Mr. Agostini, that, you've not been terribly diligent about getting the necessary approvals to have a place to put that trailer or a business to replace it. Its present location on 298 Geneva Drive, it has been there past the extension. Even though it may work a hardship, I'm going to give you until April 30th of this year, 5 p.m. on April 30th, to move the trailer. If it's not moved by then fines of $125 a day will begin to accrue. So you'll have to do whatever you have to do to find a place for it or to get the necessary approvals for some other location. But if the trailer's not gone by April 30th, you will be fined $125 a day. Okay. Yes.
Will that be the owners?
And you are, again, Mr. Wilson.
Rodney,
Move your mask so I can,
Rodney Wilson.
okay?
Will that fine be accrued towards us, property owners, or his business?
It's going to be directed to both of you. In other words, if it's not gone by April 30th, actually, you're the property owner.
Right.
The fine will accrue to you.
Okay.
Yes, sir.
Thank you.
Yes, Mr. Agostini. Yes.
Yes, I wanted to say thank you. And one more thing. I've been working to be diligent, just complications along the way, and see what we do. Thank you. We had discussed, as long as we're moving forward on 302, that perhaps we could leave the trailer there until such time as 302 sufficient to take the trailer off?
I can't address 302 today. All I can tell you is that the trailer on 298 Geneva Drive has to be gone by April 30th, or the fines of $125 a day will accrue to the Wilsons.
Yes.
I'm giving you plenty of time
You are.
to try to salvage the situation.
Right.
Considering that you've already had a year to do that, I think that's very generous.
I think that's extreme.
But I sort of tell you now, if you come back for an extension in April, I'm not going to be inclined to grant it. It's time to, as they say in old Florida, fish or cut bait,
I got you.
okay?
Okay, well, I really appreciate your generosity, and thank you.
Okay. I will be submitting a written order, and the city will be mailing it to you. All right, the next item on the agenda is case CE 25-000009. That's only the ninth case this year, involving John and Francine Lentis. The property is 1007 Kelsey Avenue, Oviedo 32765. Parcel ID is 23-21-501-00-0250. The allegation is the maintenance of a public nuisance, which would be a violation of ordinance 22-144C9. Who's going to be doing that on behalf of the city?
That would be me.
Ms. Longstreet?
Yes, sir.
Okay. And that's Lindsay Longstreet.
Yes, sir.
Lindsey.
Yes, sir.
All right, who's going to be speaking to this other than Ms. Longstreet? Anyone? Yes, sir, would you come forward? And you are John Lentis. All right, would you both raise your right hand? You solemnly affirm that any testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? All right, we'll hear from the city, Mr. Lentis, then we'll get to you. Okay?
Good morning, Mr. Special Magistrate. I have a package of 20 pages that I'd love to submit evidence about.
Okay, put that microphone a little closer. Thank you.
So I have a package of 20 pages that I'd like to submit evidence. if
Yes, thank you,
bench.
Bree. That's been supplied, a copy to Mr. Lentis. Okay, 20 pages will be entered into evidence as city's exhibit number 1. All right?
On January 8, 2025, I received a complaint about several violations at the property of 1007 Kelsey Ave. However, we are here today specifically for the unsecured pool this time. So after I received the complaint, I proceeded forward with the code enforcement process. Pages 1 through 4 are going to show the property record card showing John and Francine Lentis still own the property at this time. Pages 5 through 8 show an old lot move order and email that was sent to city staff from a lawn company with photos of the backyard showing that the property does have a pool. And also, if you flip back to page 3 of the property record card, it does note that this property of Kelsey Ave has pool. I just kinda wanted to get into that to show there's a pool at this property.
Okay?
So page 9 was January 8th. It's the photo of the house where the violation is at. And then 10 and 11 show the fence in this disrepair, thus the pool being unsecured at this time. And this is the back of the house from the street over.
Okay, the fence is fairly dilapidated.
Yes, sir. And then page 12 is going to be the notice of violation that was issued to Mr. Lentis, showing that he had until January 11th to place a barrier to fully secure and enclose. It was certified mail. Page 13 is the receipt, and page 14 is the signed green card. He was also spoken with and delivered a notice on the 8th as well, just due to the nature of it being an unsecured pool and a safety hazard. So I spoke with him on the 8th, advising of the pool to be dismissed 72 hours, which would the commence date of January 11th, 2020. And then pages, so prior to my reinspection, I did speak to Mr. Lentis. He had called to advise me that he was going to be unable to secure the pool at this time due to financial restraints and other personal issues. So we did go back out and inspect the property on January 14th. So pages 15, 16, and 17 are the inspection photos still showing where the fence is missing and allowing it to be unsecured.
Okay. I'm going to look you back at the pool again. Just a second.
And then page 18 is a copy of the notice of hearing that was prepared for today's hearing of January 23rd, 2025. He was sent a copy certified mail. This is, page 19 is the certified mail receipt. We did not receive the green card back yet at this time. However, page 20 is going to be the affidavit of hand delivery for
Right.
the hearing.
Well, I find it's a threshold matter that all notices required by ordinance and Florida law have been provided to the respondent. Excuse me, but I want to look again at this pool or excavation.
So in closing, this property is obviously still in violation at this time, causing an imminent threat to public safety, thus us being here at the special magistrate
Okay.
today.
Well, I say that the fence is clearly a violation.
Yes.
The pool itself, I guess this is a swimming pool?
Yes, sir.
Is any problems with the state of the pool? I mean, is it dirty?
We were unable to determine the state of the pool. We weren't able to see it on the day of. Just, that's why I provided the old case history to show that there was actually a pool and the property record showing there is a pool. Due to the fence being up mostly around the fence and the grass being tall, I could not view the pool myself that day. But it was also confirmed by Mr. Lentis that you have the pool. As far as the condition of what the pool looks like, not sure of. No, it's unsecured at this time.
So in addition to the fence, we may have a problem with the pool that is a breeding ground for
Yes, sir.
disease, and
Unsanitary.
so we don't know that at this point in time.
Correct.
All right, anything else for me?
No, sir, that's
All right, Mr. Lentis, we'll hear from you.
Good morning, Your Honor.
What do you have for us, Mr. Lentis?
Well, like she said, she was right, the pool's not up to date. I have a lot of physical disabilities. I can't take care of the fence, the grass. The previous code enforcement, Dave Stevens, he had gotten the ultimate image, people that do the development to come and cut my grass and do what's needed. But I mean, right now, my mom's helping me with my mortgage. I'm disabled, I'm on disability, I make $600. And that pays for the, for where like, I mean, I want to participate, it's just I'm physically unable to. My wife just got through breast cancer, and we're indigent.
Well, Mr. Lentis, here's the problem. As an attorney over the years, I've handled numerous cases where children have gotten through fences that had holes in them and drowned. So I'm very sensitive to that issue. And the city's very sensitive to that issue. Right now, you have a pool. I don't know what sort of condition it's in, but it looks from the photographs that it may be in a state of disrepair itself. Do you swim in that pool?
We used to.
How long's it been since you swam in the pool?
Probably a year.
Okay.
I've been able to do
But
anything. I can't even work.
Well,
I mean, I know I'll have to get, I don't even have transportation. I mean, I have to walk.
something's got to be done about the
Yeah, I
fence,
have to
Mr.
get,
Lentis.
I have to get my neighbors, some of them, to go out and buy, get shock it, and do that. As for the grass and the fence, I need help.
Yeah.
I know it's gonna be a lien, but I have no other choice. I can't physically do it myself. And I don't have anybody, I mean, I've been here 25 years.
Yeah, well, I certainly sympathize with your situation, but we cannot have that fence open
Yeah,
where
I mean,
some kid can get through and get drowned.
Yeah, but there's no children in the area.
It doesn't matter.
Yeah.
Sometimes they, you know, it does happen. I can tell, you know, I could tell you stories that the last case I had, little girl was named Sunshine. She wandered in, the pool was so dirty that they had trouble finding her. When they got her out, she was brain damaged. I'm not going to give you a long time to fix that fence. I'm going to give you 30 days. That would be, and frankly, I'm being generous and hoping that nothing happens in that time. If you think you have problems now, if some child comes in there and drowns, you've got real problems. I'm going to give you till February the 20th. (5 p.m.) to secure the fence so that no one can get through it and get to that pool. I'm not ordering you at this point in time to make any corrective measures on the pool simply because I don't know what its condition is. But I suspect it's probably also in violation of the statute. Certainly, the fence is a public nuisance. If it's not corrected by 5 p.m. on February 20th, then fines are going to accrue at $50 a day until it's corrected.
Now, I have a question. Could Public Works in Oviedo actually come out and fix the fence?
You can talk to them about that, but that's nothing I can tell you. Ms. Moyer, you?
Yes, sir. I just wanted to state that in order for him to secure the pool, we didn't issue the compliance date for the fence because the fence doesn't necessarily have to be the barrier for the pool. You could go and get a child fence that would go around. So that's less costlier. That's something that you bought in the store
Okay.
on Amazon. So there's other ways for him to secure the pool that's less costlier to ensure safety for children. Which is the less costly way, because if you get the fence, we're talking maybe, depending if you're replacing it, that can be in upwards of the thousands. With that other option, which I would encourage you to go to the building department and speak with the building official. He can tell you exactly what you would need to have, which is a less costlier way, and I say that because we deal with a lot, for you to be able to get that in compliance. I think that's very reasonable. It should be reasonable, even if it's borrowing. I mean, that would have been something temporary, but no, sir. It's a childproof fence, so it will go from one end of the pool to the other. That's the big. Yeah, so they'll give you the information on it next door, but it's a less costlier way, and we've had people use that because that, by the Florida Building Code, is an improved way to secure the pool. It doesn't even have to be 6-foot fence that wraps around the property, although you'll still be in violation at some point for that. But to immediately secure it, there's a less costly way for you to do it, absolutely, for you to
Yeah.
get it secure.
Yeah,
So
we're talking
30
about
days-
securing the pool, not the yard at this point in time. But it's got to, whatever you put around the pool's got to be something that is an approved child barrier. And Ms. Moyer's right, they do make those things, because I had one put around my pool at one point in time. I bought it. Well, it was just one of those things that is sort of interlocking. It was like a rail system. And I don't even remember where I got it at the time, but however you do it, the pool has got to be secured so that no child can get in. Okay? And I wish you well.
Thank you very much.
Thank you. Anything else to come before us today?
No, sir.
All right.